Step.
Thank you, Mr. Chair. Good representative. I'm just trying to be clear in my own mind. So if a child is trespassing under this law, which doesn't seem to distinguish one kind of trespasser from another, would the landowner, and the child gets injured while trespassing, would the landowner have no liability in that case? Is that what you're saying?
That is correct.
Okay, thank you. Speak to the bill, Mr. Chair.
Representative Staff.
Thank you. So, members of the body, Mr. Chair, there is a well-settled doctrine ever since England and common law called the attractive nuisance doctrine. And it was created to design, to protect children. This bill would therefore wipe out that doctrine. The doctrine itself recognizes that children are sometimes incapable of understanding or appreciating dangers or risk. So if a landowner concurrently is not liable for, let me take that back. What the doctrine says is that a landowner is liable for injuries to a trespassing child, but only if and only if there is a hazardous condition on their property that is enticing to curious children, and that hazard is left unguarded in a place where children are accustomed to play, and where it was reasonably practical to prevent access by children or to make it so that the hazard doesn't impose a danger. So this usually applies in situations like some unfenced swimming pools, open pits, abandoned cars or refrigerators where children are known to play and then can get injured. So the big impact of this bill really would be to wipe out that principle and make landowners no longer responsible to keep their property safe even when they know that children are prone to playing there because there is what is called an attractive nuisance. Members of the body, I urge you to vote no for the kiddies. Thank you, Mr. Chair.
Is there further discussion? Representative Fuller.
Thank you, Mr. Chair. I have a question for the good representative in seat 34, please. He would yield?
I yield, yes. Thank you.
Mr. Representative, Mr. Chair, if a child goes onto a piece of property that has an attractive nuisance, would you support the also charges against the parents for negligent parenting?
Mr. Chair, good representative, I don't know what kind of charges you might be referring to. This bill, of course, that's outside anything this bill does. This bill is, what the effect of this bill has to do with attractive nuisances where it's known that children are prone to play there, as of the type that I discussed. It has nothing to do with the parents or charging them. I don't know if you're talking about criminal charges or civil charges, so I really don't quite understand. But I do know that this bill would wipe out centuries of precedent that is designed to protect children, Mr. Chair. So, Mr. Chair, good representative, there's a good deal of case law on this. I'm not familiar with any case that has ever held a tree to be an attractive nuisance. The cases I'm aware of are almost always things like unfenced swimming pools, open pits, abandoned cars, or refrigerators. The part of the equation is whether the landowner knows that children are in fact playing in those places, and it's reasonably practical to making it safe. It is a case-by-case decision for the courts in looking at these criteria. It's well developed, and it has been. It's not some modern trend towards against property rights or anything like that. This is something that has been the law in this country in every state, as far as I know, since we've been a country. When I was a kid, I played sandlot baseball. I'm not quite sure who owned that sandlot, but all the kids in the neighborhood played there, and my parents knew I played there, and so did the owners. I presume because we played there every day. And there is, on the part of the owners, if they constructed a big pit in the middle of that and knowing kids play there, they might be responsible for that. So that's where we are, and that's why I oppose this bill. Thank you, Mr. Chair.